Alright, I got three separate sources of information, largely within the ordinance for Outagamie County. And this is just the beginning. It's not the actual section for the law itself against camping. I'm trying to find other information within the ordinances to help me understand their thinking. What's going on with the ordinance as a whole, all the chapters and all that, and run it through ChatGPT if I have any questions about what's going on. And I think I did run through ChatGPT. Yeah, here in the yellow, I did run through ChatGPT, and that's just to compare the ordinance to the state, which I can go over. But this is the general penalty, which I find interesting, because I thought it was 6 months, but it's saying on first offense I'm looking at 90 days. Any person who shall violate any provision of this code shall, upon conviction, forfeit not less than $5 and not more than $500, together with the cost of prosecution, and default of payment of such forfeiture and costs of prosecution shall be imprisoned in the county jail until such forfeiture and costs are paid, but not exceeding 90 days. So and it says, let's see, forfeit, who shall violate, okay, and in the default of payment of such shall be imprisoned. So they have no choice. If you don't pay, then they have no choice but to throw you in the county jail for 90 days if you refuse to pay. So that's pretty serious. It's not may be imprisoned, it shall be imprisoned. And that's different from what I saw, and I don't have the comparison, but I heard 6 months, and this one's saying 90 days. So where do you get a lawyer to help you navigate the legal process to avoid jail? Alright, they're skipping out on the lawyer, the free lawyer part, but still holding jail over you if you don't pay. And it's a punishment, it's a penalty against being poor. And at some point, people got to call them out on this, that even though there's the first step of finding you guilty and then you owing only money, and then when you don't pay, that's when they can jail you. And in that whole entire process, the due process, there's no opportunity for a lawyer, a free lawyer. And people are getting put in jail who qualify for free lawyers as a part of this process, this very process. People are likely, okay, I'm assuming, people are likely being put in jail as a part of this process who qualify for free lawyers, yet are denied that and still end up in jail. Okay, that's a constitutional issue. And then if you do it again, let's see, 6 months, right? 6 months, not exceeding 6. Okay, 10 to 500 on the second offense. So it's a little more severe, from 90 to 6 on these offenses, and they're saying this is covering all the provisions for the general ordinances, all the ordinances. If you don't pay, you go to jail, and you don't get a free lawyer, and you don't get a jury, and it's just pay or go to jail without any legal protections, any legal oversight. It's just kind of straight from the judge's mouth, and they can decide between 5 and 500 based on their feelings for that day. They can convict you, they can they can decide what you owe. It's very arbitrary. It's very loose. And they're playing the law way too loosely. They're playing this part of the law way too loosely. They're playing the open records way too loosely without any undue hold-ups for the public records. I mean, they just play everything way too loosely, skirting around our civil rights in Wisconsin. Let's see, we got an ordinance here. Now I find this interesting. The citation that I got does have a name and address for me, but it does not have number 2, factual allegations, and I'll show that. It does have the time and place. It does have this section of the code, a designation of the offense in such a manner as can readily be understood by a person making a reasonable effort to do so. Okay, I don't quite understand what that means. I mean, without the factual allegations, number 5 is also a bit sketchy. The time, a statement which informs the violator that a cash deposit based on the schedule established by the county board from time to time. A schedule established by the county board and on file in the office of the sheriff and county clerk may be made in cash or check. No credit card. They get a receipt. Okay, and then all this is just if you pay. So, an action may be commenced to collect the forfeiture. If the alleged violator elects to make... Okay, an action may be commenced to collect the forfeiture, which that action obviously is what they're saying here. An action may be used to collect the forfeiture. Well, that's also called default of payment of such forfeiture. So you shall be imprisoned. It's a guarantee. Okay, you could be found guilty and have to pay, but jail time is definitely on the table still. You aren't out of the clear after conviction, just because they give you a fine after a conviction. You're not out of the clear. And it's hard to say how low they'll go to toss you in jail. If you owe $50, well, they put you in jail for that until the time you pay. If you owe $50, will they keep you in jail for 90 days until you pay that $50? They don't explain the threshold. That's something for the judge to decide. Without clear explanation in the ordinance, that's what the judge is going to decide based on his or her attitude for the day. Alright, now I'm going to show that ticket. I'm going to skip over this. I just put a ticket at the bottom. So this is the ticket, and they have the date and time, the name, okay, oh yeah, the location, the officer's name, there, okay, but not his full name. I think that Outagamie was trying to convince me that the S stands for sergeant when it stands for Sean. So he was using some, the first initial of his name. He was using some subterfuge. He was trying to fool me into believing that the S is sergeant. and it didn't make sense to me. I mean, maybe other people got confused and would have assumed Sergeant Oligny, the SS, but I mean, I've seen so many police tags, I've seen so many police names that doesn't fool me. I mean, they all have the first initial of their first name, so it's not a sergeant thing. And I think he was kind of trying to fool me with that. Okay, but what this ticket is missing is the violation description. Okay, there's nothing. he can he can fit the easy stuff, camping in an unauthorized area, type that out all in capitals, and everything else. But he can't put a description, and he shall put that as a description. He's required. So that's the problem we're having here with this, and that's something that I have to bring up now. Now that I'm aware of the statutes, it's amazing how Sean Aligny can read the statute about camping, but he can't read the statute about how the ticket should be filled out. Okay, he's got a standard that's very selective, and he chooses what's easy. So I want this to go through. I mean, I want them to be successful in this court hearing, but I'm gonna throw out the option to the court and say, I'm gonna cite the law that it says the citation shall contain in Outagamie Ordinance section 116. The citation shall contain the following. Number 2, factual allegations describing the alleged violation. And I want to bring that into evidence, okay? I have to bring it into evidence, so I think I might need to make a motion, not just make it verbal in the court. So I might want to return to the courthouse again and submit the ticket as evidence and point out that, this is Exhibit A, point out that the violation description is blank, while the ordinance says that it's not supposed to be blank. And what remedies will I be seeking with the judge? And I'll put that in the motion, I think. Alright, I'll say one of two things should happen. You either rewrite the ticket or dismiss it for lack of information, for going against the ordinance. And I'll make the argument that I've been languishing for weeks, waiting on the court dates, not knowing what the actual offense is within the charge. What are the facts? Okay, you have me languishing, and that's a due process thing. All right, I sit in question, in doubt of what I should do, because I have nothing to respond to. They've given me nothing to respond to. So how do I put that into words for a motion and for an argument in court that you can't just write a ticket putting the charge without some facts and make me have to just sit and question what exactly the charge is? If the court read this at face value, what would they assume? What are we all to assume? But I want to give them the option. I want to say you can either rewrite the ticket, but know that this is a prejudice. If you just turn to rewriting the tickets, this is still prejudice against my due process, or dismiss it. All right, and then I created some arguments here, and I just need to remember what this yellow is. It does not comply with the ordinance. Oh, this is the actual argument. Okay. Clearly cite the Outagamie Ordinance, emphasizing that the ordinance uses shall, and I told ChatGPT to do that, to say that shall is defined as being a mandatory requirement. The statute states it means being mandatory. The county ordinance also recognizes that as mandatory. Shall has a specific meaning. Compare the ticket to the ordinance. Present the ticket to the judge. It's Exhibit A. Point that it does not contain the factual allegations. Explain that without these factual allegations, the ticket fails to meet the requirements set forth in that section. Explain the importance of compliance. Argue that the inclusion of factual allegations is essential for you to understand the nature of the accusation and to prepare an adequate defense. This whole time, I have not been able to prepare an adequate defense, and I've been making discovery requests and not getting answered. Emphasize the ordinance's requirements are there to ensure fairness and due process, and failure to include this information violates my rights. Provide precedents or similar cases. I don't have any. If anybody knows any good cases to cite, that could be helpful. And it's pretty much a failure of Oligny, Sean Oligny, to complete his ticket. This can help support your argument. Yep. Based on the lack of compliance with the ordinance, request that the judge dismiss the ticket. Yeah, I also would like to, I would first want to say, I want to give you an opportunity to rewrite your ticket. Even though this is a due process issue, I want justice to be served here, honorably. But I mean, there is dishonor in not completing the steps required for this process. Simple argument. This is what I could just copy and paste as a motion. According to the ordinance, a citation must include several pieces of information, including factual allegations describing the alleged violation. The use of the word shall in the ordinance indicates that these requirements are mandatory, specifically Section 116.2. And I just want to add that ChatGPT added that too. I was a little worried that it wouldn't, but it did. So it's very specific. And it states that a citation must contain factual allegations describing the alleged violation. However, the ticket I received does not contain any such factual allegations. This omission means the ticket does not comply with the ordinance. The factual allegations are crucial as they inform the alleged violator of what exactly they are being accused of, allowing them to prepare a proper defense. Without this information, the ticket is not only deficient, but also violates my right to due process. In light of this non-compliance with the ordinance, I respectfully request the court to dismiss the ticket. And that's it. Just making an argument about this. I mean, this ticket's that's lacking, but I mean, I have further arguments to make, but this is the very basic first hearing type of thing to bring up is just the ticket itself. What we're sharing in court is going to be a discussion about this ticket between me, the prosecutor, and the judge. And I don't know how it's going to go. I mean, I watched the judge a little bit. I didn't watch him enough to learn enough of what to expect exactly. But yeah, just got to bring this to court.